first season is at a close, and I'm so proud and pleased about the episodes we have brought to you. Our first season was all about standards and what happens when every standard we trust in DUI cases, whether it's driving cues, constitutional standards of proof, field sobriety tests, or chemical results, falls apart under closer scrutiny. Today, we're putting all of that together for you in one case. But first, let's recap. In episode 1, we discussed the different standards of proof, covering reasonable suspicion, probable cause, and proof beyond any reasonable doubt. We went all the way from the traffic stop to the verdict and explained how the different standards of proof govern police action throughout a case. Then, in episode 2, we talked about the difference between Fry and Daubert, the two cases governing how scientific evidence is admitted into courts today. Fry focuses on whether the evidence is the type of evidence generally accepted in the relevant scientific community, while Daubert, with its multi-pronged analysis, designated the trial court as a gatekeeper and said if the evidence does not pass these tests, including a known error rate and a reliable method, then the evidence is not coming in. Episode 3 took us through the big 3 cases involving scientific evidence and confrontation: Melendez-Diaz, Bullcoming, and Smith versus Arizona. All 3 of those cases explained how important it is to have the person who is creating the evidence in the crime lab to be used in the criminal case be the same person who testifies to the evidence in the criminal case. Episode 4 was an expose episode regarding the fields. I went deep into the studies, talked about percentages, correlation coefficients, regression analysis, and we came away with the concept that the field sobriety tests are not doing what they claim that they can do at all. In our mini episode, episode 4.5, applied that same analysis to the drug recognition evaluation program. Episode 5, which we just aired, was all about chemical testing, and we briefly looked at the issues in breath and blood testing, both for alcohol and drugs. We talked about biologic variables in breath testing, fermentation and carryover issues in blood testing, and came away with the thought there can be errors in chemical tests even if there aren't error messages on the paperwork. And now it's time for us to put it all together and talk about some real-world case examples from my practice. Each and every instance that we're going to cover is going to come from a case that I have handled. However, in order to protect the identity of my clients, I will be changing their names. And instead, we're going to do something fun and discuss the criminal capers of my canine cutie, my dog, Disco Dazzle, or as he is better known when he is in trouble, Bubba Jack Charles. He is just a doggone DUI, and it is a doggone shame. So as we bring season 1 to a close, Beyond the Breathalyzer is proud to present the state of Arizona versus Bubba Jack Charles, a canine criminal caper. Bubba Jack Charles was pulled over by the Tucson Police Department for speeding on Congress as he was heading out of downtown Tucson. The posted speed limit is 25 miles per hour, but he was traveling 40. I will note, as his devoted doggy defense attorney, that it is a common speed corridor, and officers often sit along Congress and wait for drivers to come along the road, as it is an egress out of downtown where there are a number of bars and drivers are headed to the highway. Bubba Jack was in the far left lane when Officer Paw Print lit him up for speeding. He responded right away to the officer's signal to pull over by activating his turn signal and made not 1, not 2, but 3 safe and complete lane changes in order to get into the right turn lane and make a right turn on the frontage road next to I-10 before then pulling in to the Circle K parking lot. From the time Officer Paw Print activated his lights to the time Bubba Jack was stopped, no more than 20 seconds had passed. The constitutionality of this stop would be analyzed by the reasonable suspicion standard. Was it reasonable for the officer to suspect that criminal activity was afoot? Well, not criminal activity, as I will discuss in a minute, but there is no judge in the country that is going to say if the officer thinks the driver is speeding, he cannot pull the driver over. As for criminal activity, this driving behavior is not driving behavior that is associated with being under the influence. Speeding is not a drunk driving cue. Too many sober people do it. And if we pour a little Fourth Amendment on this, we can see the problem right away. When normal driving is used as evidence of impaired driving, then every sober driver becomes a suspect. Activating a turn signal and making 3 safe lane changes is the opposite of what we would expect to see from a DUI driver. Bubba Jack's response to the signal to pull over was safe, careful, and normal, indicating again that he was not impaired. Officer Pawprint knew that he could see evidence of impairment in the way Bubba Jack responded to his signal to pull over, as his training told him he was likely to see it. Since that didn't happen, that is significant evidence of sobriety, and it comes into play later on. But as for reasonable suspicion for the stop, the speeding itself will do it. So then Officer Pawprint approached the window and asked Bubba Jack for his license, registration, and insurance. Bubba Jack handed those over without any issue. The officer noted an odor of intoxicants and bloodshot eyes. It should be noted that it's 2 o'clock in the morning. Bubba's speech was fine, his cognition was fine, his visual acuity was fine. All of these are things that officers are trained to look for in a DUI case. Dexterity, which is how they handle their documents. Cognition, which is how they answer the officer's questions. Speech, is it normal, is it slurred? Visual acuity, are they handling the right documents? And divided attention, can they do a physical task at the same time that they do a mental task? Remember, Bubba Jack's response to the officer's signal to pull over was safe, careful, and normal, a display of good divided attention. But despite not seeing any indication of impairment, and instead only an indication of ingestion, Officer Pawprint makes Bubba Jack get out of the car for a DUI investigation. This is called detention analysis, and it is also reviewed under the reasonable suspicion standard. Was it reasonable for the officer to suspect that Bubba Jack was impaired by alcohol to the extent that he needed to be detained for an investigation? In my view, no. There is no bad driving. In fact, there were several instances of good driving. Driving that was the opposite of what we would expect to see in a DUI case. There were no observations made of impairment, merely ingestion during the personal contact phase between Officer Pawprint and Bubba Jack. It was reasonable to suspect that Bubba Jack drank. Bad dog. Although in doggy years he is, in fact, old enough. But not that he was impaired. And drinking before driving is innocent activity. You can consume alcohol and drive a car, you just can't be impaired by the alcohol when you do. The judge disagreed and found that the detention was reasonable. At that point, we moved on to the fields. Bubba Jack did moderately well on the fields. I argued, however, that the horizontal gaze nystagmus test was conducted too fast, and that given his physical limitations, he wasn't a good candidate for the one-leg stand. The judge agreed, and under the Daubert standard, found that the results of those two tests were too unreliable to be presented to the jury. This is the Daubert standard, and the judge doing exactly what they were expected to do, keeping unreliable evidence away from the jury. But despite all of the good driving and Bubba Jack's successful divided attention, the judge upheld the arrest, finding probable cause, and we then proceeded to trial. In Arizona, officers can select which chemical tests they want to do, but nothing stops them from doing both. And in this case, there was both breath and blood. Poor Bubba Jack. He had such a hard time giving a breath sample. It ended up not mattering anyway. Procedurally in Arizona, the breath test must be accompanied by a worksheet, which is known as the G2 worksheet, and an officer fills that out at the time of the breath test. It is a checklist of procedures that the officer is expected to follow. If there is no checklist, the officer's testimony that he or she followed the checklist is sufficient to establish the requirement that the checklist was followed. In Bubba Jack's case, however, the breath test officer didn't use the checklist and testified at the motor vehicle hearing that he didn't know he was supposed to use a checklist. He filed a motion in limine and the breath test result was kept out since the statutory prong for admission of the breath test could not be met. The blood test, however, was a different story. After Bubba Jack was arrested, he called his attorney, something he has the right to do, and it can never be mentioned in court at all. During that time, he was transported to the police station, and a different officer, not Officer Pawprint, instead it was Officer Milkbone, who came in, drew the blood, packaged it, sealed it, and put it into evidence. While Officer Milkbone claimed to have drawn the blood, both officers claimed to have packaged, sealed, and entered the blood into evidence. This was a big discrepancy in Bubba Jack's case. Sometimes, attorneys will use discrepancies like this to try and work a deal. I usually wait, because often, in cases, and in this case it was also true, the officers could have talked to one another and decided between themselves who did what and when they did it, and that credibility issue, that chain of custody issue, would have been gone. So I waited until the officers testified at trial to ask about it. I showed Officer Pawprint the report, where he claimed to have entered the blood into evidence after getting him to state that his report was thorough, accurate, and complete. I then showed him the chain of custody, where it indicated that Officer Milkbone was the person who entered the evidence into custody. He had no explanation, neither did Officer Milkbone. 2 officers, 1 blood kit, 2 separate stories. Add to that the presence of ethanol in the negative control, and the state's case was firmly in the doghouse. When the state tests blood, they run a series of calibrators and controls, one of which is a negative control. That negative control is supposed to be blank. It is supposed to show that there is nothing that is being carried over from sample to sample. Except, in Bubba Jack's case, there was just the smallest bit of ethanol. It was small, but it was identifiable. As I argued to the jury, and as I have said on this channel, I don't care how big the roach is in my salad, I'm not going to eat it. If there is ethanol in the negative control, that means the blood run has failed, which means the test results are not valid. With all of the issues shown, the jury did not believe the blood test results and did not believe Bubba Jack was impaired. And when the jury stopped trusting the state's evidence, the entire case collapsed. The state was not able to prove the case beyond a reasonable doubt, and Bubba Jack Charles was exonerated, not guilty of all charges. Now this little case example, which encompasses real examples from many different cases that I have taken to trial, shows the 3 standards of proof. Also shows where we used Daubert pretrial to have 2 of the 3 fields and the breath test results precluded. How the facts came together to argue non-impairment and a lack of credibility in the blood test results, resulting in the not guilty verdict. The state cannot appeal an acquittal. Bubba Jack Charles was the happiest, goodest of the good boys, and the case was closed. These examples show why standards matter and why each step along the way matters. It also shows you how the standards, when applied correctly, can force a system to do what it was supposed to do all along. Make the state rule out any reasonable doubt before that presumption of innocence can ever be overcome. We've had so much fun with you this season and are looking forward to season 2, where this season has been about standards and how they are applied. Next season is going to be all about trials. We're going to take you into the courtroom with us, figuratively speaking, and give you that exclusive behind-the-scenes look at how a DUI case is prepared for trial. Until next season, which is coming in a few weeks, thank you again for being part of season 1, and I will see you behind the scenes and beyond the breathalyzer.